Hi there, it's Rachel Lamar with Lamar Real Estate, and I wanted to talk about dual agency. For those who don't know what that means, it is simply when, I say simply with some sarcasm, when an agent or a broker represents both parties in a real estate transaction, so buyer and seller. Now, some states do not allow dual agencies. They are illegal. Here in California, we do allow them as long as both parties are presented with several disclosures that state the nature of the dual agency and they agree in writing. Now, the easiest way for me to explain why I personally am against dual agency, and I have to give a caveat. I have done, I think, 2 transactions where I did represent both sides. So I'm not being a hypocrite. They were very unique situations. One had a very different kind of financial situation that kind of was what was holding the whole deal together. And the other one had some unique circumstances as well. But aside from that, normally I don't like to do them, and this is why. The best example that I can give you to show how why they aren't so great is if you think of a court of law. If you are going into a court of law and you are going to sue somebody, you are not going to go and hire the same attorney who's representing the party you're suing, right? Because A, that's not allowed, but B, you would jeopardize your whole case. Why would you have one attorney whose fiduciary duty is to protect you and represent you to the best of their ability, also represent the other side? Because of course the attorney is going to know, going to be privy to knowledge from both parties, and how can he or she adequately represent your interests? Doesn't work. So it's kind of the same thing in real estate. And if you look at it in the light of real estate being a legal transaction, because it does involve legal binding contracts, and most people are not represented by attorneys in these situations, but if you are represented by an agent who has, let's say, confidential information from the selling party, and let's say you're the buying party, and let's say the seller told the agent some things such as their bottom line, what they're willing to negotiate, etc., and then the buyer comes along and flat out asks you as an agent, what's their bottom line? What are they going to negotiate? Well, if you answer that question, you breach your duty, you breach your fiduciary duty to the seller. But if you don't answer that question to the buyer, aren't you breaching your fiduciary duty to the buyer? Because how can you adequately represent someone when you're not disclosing something you know? But how can you disclose something you know when your duty is to not do so? So you can see where it puts an agent in a very difficult position. And this has been the subject of a lot of lawsuits. It's created negligence and other issues. So my advice is, I know a lot of buyers like to go to agents to represent them in a dual agency, but my advice is to get your own representation to make sure that you're protected, because again, this is a legal transaction. It involves binding contracts, and you want to make sure that the person who's working for you really has your best interests at heart. So if you want to read a little bit more about dual agency, you can go to my blog site at rachellamarrealestate.com or my website at lamarrealestate.org, and you can scroll down to the bottom and see the blogs. And on the blog site, you can click on dual agency on the right in the menu, and I've written I think a couple blogs on that. But if you want any more information, feel free to call me, email me, text me, and I'd love to answer your questions. Have a great day.